Angela starting.
I'm here on that matter.
We can't
Yes,
hear.
that would be me. Jorge Olivas Jr. Yes, there is already. There is a final decree of divorce and a joint custody agreement finalized in 2011.
We can't
Oh,
hear.
for today? No. I don't even understand exactly why I was sued yet.
No escuchamos.
No, that is not my understanding. From when this whole thing started, I was sued, but I never even was told what the nature and the cause for the lawsuit and why exactly caused anything to become a legal proceeding. And I have asked for that discovery. I've asked for the nature and cause to be disclosed. And Mr. Conacher has not disclosed that, has not let me know what that is, and has not even had a conference with me at all on the matter. Yes, when I initially answered the lawsuit, I asked for proof of claim, or which would be your discovery request. You know why I was sued, and I have yet to be told. That's incorrect. The original request for filing was actually done as my answer to the court, and that's when I asked for nature and cause or proof of claim. That was my request for him to disclose why I was sued. And this whole matter is taking place, but he's not. Well, Rhonda Doe has not disclosed why she sued me. Mr. Conacher, I have requested for him to even prove that he has a Texas issued license to practice law, and he has yet to even prove that. He submitted a resume, but I don't know that he's actually an officer of the court. Can he provide the license, please? Well, the reason for the question is because I called to see verify from the roll of attorneys from the Supreme Court of Texas as well, and they don't have a Christopher R. Conacher in the roll of attorneys for Texas. Like I said, I'm not even sure why I was sued yet. The nature and the cause for the proceedings have not been disclosed. What is a factual, what is a statistical closure on the case is only the agreed judgment that me and Rhonda have back from 2011, which was an agreed joint custody agreement, and it was an uncontested divorce. She's suing me under temporary orders, it seems, but the standard of regularity is not being followed for a agreed judgment on this case because there is a contract between me and her, and she's suing me outside of the contract. Temporary orders are not proper when there's already a final order. the modification, for the joint custody contract, if I may refer to it, states that she has the obligation and the duty to let me know on anything that has to do with the health or the well-being of my sons. And not only does she have the duty to do that, but she has to let me know in a formal notice or some sort of notification to me in the court and the court afterwards before any litigation is ensued. And she did not confer with me on anything. I don't know, like I said, I don't even know what's the cause for me to be sued. What is the reason? I mean, she's not proven standing to sue me under the circumstances. I didn't go through a custody evaluation. The custody evaluator sent me a letter. Then she says that I got the information for the supposed the initial Zoom meeting with her so that we could discuss everything. But she didn't send me anything, and I had to. She sent it to a wrong email. She's never corresponded with me through there, but so I didn't get the information, and I wasn't able to assist her in any way to show up for that. Nothing was told to me or disclosed, and I was never found to be an unfit father. So I don't see why there's a custody evaluation to be done on me if the standards of regularity are to be followed.
We have no agreements. The issues would be conservatorship, support, and access. That's my understanding.
And the OAG is also an intervener in this case, for lawyers.
Okay, Ms. Malmo. Your Honor, I'm an ambulance attorney that was appointed by the court. I do not have enough information to make any kind of recommendation, so I'll have to listen to the evidence. I have met with my clients, I know what they want, but I do not have any information, sufficient information about the parenting plan to make a recommendation. Okay, did you need additional time to gather that? Well, I was going to listen to evidence. I talked to the father who was not represented. I have read what the mother is asking for and what the grandparent caregiver is asking for, but there were some issues as it relates to endangerment, and so until I know, what is and what isn't at this point, I can't make a recommendation until hearing more evidence. I do know that there was a drug issue as it relates to Dad, and since he's not represented, I don't think that he is going to be able to present evidence to controvert his last drug test, which was back in January. And I think that is very germane because it was marijuana and nothing else. So that is one issue that I see. But to answer the court's question, do I need more time? I am willing to proceed with the guidance of the court. I will certainly discover whatever I can, but it is correct that we did try to mediate. I was disappointed that no agreement was reached, but We didn't get it far. Okay, but as far as your investigation outside of the court and hearing the testimony, do you feel that you had sufficient time to investigate? Your Honor, yes, I will say that, and I'm saying this cautiously, I believe one or more of the parents, well, let me rephrase. I don't have any information about the mother. I don't have any information about the mother. As far as dad is concerned, it's my opinion that there is not going to be anything so serious that it would warrant the children not being with one of the parents, at least as far as he's concerned, because I don't have any more. If you, Judge, if you would like for me to investigate more and try to get some of that information for the court, I would be happy to do that. Okay. Any mom on here?
Yes, Judge, Baby Gilchrist for mom. I'm for mom. Kara Davidson.
The amicus doesn't have any information on mom to bring.
Right, and my client says that she has never heard from the amicus. And that's been her problem all along. She says she has never contacted her. And I knew that the amicus hadn't spoken with my client, and I never could figure out why.
Is it 2 cases in one?
Because she had spoken with Mr. West. And Judge, I have no problem.
Is it 2 cases in one?
If she needs additional time to speak with my client, so I'd like for her to be fully informed prior to making any sort of recommendation to the court. I'd like for her to be thorough, in other words, and I would like for her to speak with my client and visit with my client, and because I think it may affect her decision.
And Your Honor, I'm happy to do that. The last information that I had was that there was some bond restrictions in place. And so we don't have to go through all of that now, but I'm happy to conference with Mr. Gilchrist's client if he would like me to, but I've had no problem reaching the father.
Judge, if I can chime in real quick. If you do this, it's my understanding that the intervener, the maternal grandfather, has not conferenced with the amicus either. So I think if we're going to give the mother the offer, we should also have the intervener have the opportunity to meet with her and tell her his concerns. Because we're of the opinion that there's still ongoing safety concerns for the children.
Your Honor, I'm sorry.
Hi, yes.
I haven't had any issue reaching out to Miss. I'm Richard West. I'm the children's father. I haven't had any issues being able to get in contact with Miss Julia. She's been there anytime I've needed to speak with her. So I don't understand why the other parties have issues with reaching out to her. That's all I wanted to say.
Well, thank you. So if we reset for September 20th, would that work for everyone? Would that work for you, Mr. West?
Oh, sorry, Your Honor. Yes, that's fine. If the other parties need to do more, that's completely fine. I mean, I'm ready today, but there's more that I could do in the meantime, so I'm fine with that.
Ms. Malvo and Mr. Gilchrist and Mr. Marcellus, Your Honor, that date is available for me.
And Julia, would that give you enough time to do whatever we need to do?
Absolutely. If you
Okay.
can contact me and let me know, what you would like for me to do with your respective clients, I'll be happy to do that.
Yes, please reach out to you have my permission to reach out to my client directly. I don't need to be part of that.
Okay.
So, and Your Honor,
Yes.
I was just going to say mine also, and I'm good with September 20th.
I am also, Your Honor.
Okay, so please tell your clients they need to be available when Ms. Malvo reaches out to them so we can get the full investigation completed.
Sure.
Understood.
Your Honor, is September 20th is in person, correct or no?
Yes, we should be in person at that time. 9 o'clock, Your Honor? Yes. Thank you.
Your Honor, do I need to file what I'm asking for, or is that already standard?
That would be best. You should file whatever you're requesting.
Okay, thank you.
Okay, thank you.
Thank you, Judge.
So all have a great day.
Okay.
Thank you.
Thank you.
Okay, Azar Abdelhal and Khalid Shabali.
Good morning, Your Honor. Matthew Pedicini for the father, Mr. Shalabi. I reviewed both requested relief from us and mom's side, and we're both in agreement for parents to be JMC, mom to be primary, father to pay to support.
I know him.
The only issues are there's a house and a potential safety deposit box that we were asking to be divested 50-50, but I think that's the only thing, and perhaps just 30 or 45 minutes inside would be sufficient.
The OAG intervened in the case, Your Honor, and there is an issue of health insurance and cash medical.
Okay. And Michaela Lockett for the petitioner. I agree, but we also have an issue in regards to community debts. I'm not sure if that is an agreed matter.
Yeah, we would agree that it's split.
Okay.
Okay, so Ms. Lockett, is your client in agreement with the 50-50 split of the real property, the safe deposit box, and the debt?
No, she is in agreement with the community debts being split 50-50, but there is still the issue with the residential house and the assets in the safety deposit box.
They haven't settled anything yet.
Okay, and what is she asking for with regard to the residence?
In regards to the residence, she is asking that she be awarded the residence as her exclusive property, and a lien be provided to the respondent for any equity that he is owed in the house. Now, there is an issue as to whether or how she can pay off that lien. She is open to any options, such as being responsible for 100% of the debt and maybe paying him a portion each year when she is provided her tax return. And in regards to the deposit or the items in the safety deposit box, it is our argument that those items are her separate property. They were a dowry that she received prior to the marriage, and she has exclusive access to the safety deposit box, so she is asking that she be awarded those items as her separate property.
Okay.
Can I ask something? That's okay?
No. Yeah. Oh, okay. Okay, well, we are going to start with Jorge Olivas and then Muhammad Mahari. Let me see. It's 9:17. So at 11 o'clock, we'll begin on Muhammad Maharmi.
Okay, Your Honor.
And then thereafter, it'll be Azar Abdelhak.
Okay, Your Honor.
Okay,
We'll just leave the video and, for now.
sure, and you can do whatever, yeah. All
Thank
right.
you, Your Honor. All right,
We're
see you in a
on
little
record.
bit.
Okay, we're on record in cause number DF1109013. Please state your names for the record.
Yes, Judge. Christopher Conacher, attorney for the petitioner from the Doe.
Jorge Olivas Jr., I would be the original filing petitioner.
If the parties can announce themselves.
I'm Radha Doe.
Okay. Mr. Olivas?
Yes, I'm Jorge Olivas Jr. Are you able to hear me?
I think you're muted.
Okay, one second. Are you able to hear me now?
We cannot hear.
Hello? Are you able to hear me now? Okay. Jorge Olivas Jr. I'm the original petitioner for the divorce. Yes. Yes, I have an objection. He still gets to prove the nature and cause of the lawsuit. But I don't understand why somebody or how somebody can sue somebody without an actual cause. What was the wrong that I committed in order for me to be here getting sued for this?
He hasn't sworn in. Take the headphones off. That's the only way it's gonna work.
Is that what you and Mr. Olivas have done as far as a week on, week off possession schedule?
For a brief period, yes.
That's right. So it's not like, yeah, Asian. Yeah, she's been mean.
Your Honor, I think we have someone by the name of Carolina Olivas who is making noise. Thank you. Okay, that took care of itself. Ma'am, you just testified that you have been doing a week on, week off possession for a bit. Can you clarify for the court, what do you mean by that?
We did do week on, week off up until my oldest son, Ivan Olivas, started school.
And what year approximately was that?
2013.
And how long did that arrangement continue?
Once he started school, in September he started living with me, primarily both children, up until pretty much 2017.
When you say up until pretty much 2017, what happened after 2017 with respect to the possession schedule?
In 2017, George Olivas Jr., he stopped coming around.
Okay, and when you say stopped coming around, was it just completely 100% not coming around? Or did he come around a few times? Can you be more specific?
Yes, he wasn't involved. However, we did run into him at like one or two family events, but that was it. He never picked up the kid.
So since 2017 up until when did this kind of arrangement continue?
He reached out to me early 2020.
Okay. Is it fair to say that between 2017 and early 2020 that you raised the children by yourself or no?
Yes.
Objection.
Ma'am, I'm going to show you what's been marked for identification as P3, and judge, is a screen share enabled at this time?
Yes.
Thank you. Do you see this document on your screen, ma'am?
Yes.
Is this a financial information statement filled out by you?
Yes.
And did you prepare this document at the instruction of your attorney?
Yes.
Does this document accurately sum up your household income and expenses?
Yes.
And was a copy of this document provided to the other side for inspection and copy?
Yes.
Your Honor, at this time, I move to admit P3 into evidence.
Any legal objection to P3?
No.
Mr. Olivas?
No. There's no legal objection.
P3?
I'll have to set that up.
Give me the other laptop. I'm gonna log in. She's lying. Here, hold this.
Being here.
$1,606.
And looking at these two pages together, does this mean you have less than $100 to share each month or no?
That's correct.
And ma'am, in February of 2020, did Mr. Olivas ask to see the children?
Yes.
Did he get to see the children?
Yes, he did.
What happened when he got to see the children in February of 2020?
He started reading out loud the decree to both the children.
Did you believe it was appropriate for him to do that?
No.
Why not?
Objection. She initially started talking to my oldest son about the lawsuit and had him let her know.
No, it's recorded.
2020, ma'am?
A handful of times.
Did he take the children for the entire week each time in 2020 or no?
No.
Did he ever take the children in the year 2020 for the entire week?
I think maybe twice when they had break
Okay.
from school.
And just to be specific, ma'am, in the year 2020, when Mr. Olivas did take possession of the children, how long did he take the children each time, approximately?
In the beginning, weekends only, no overnight.
Okay. Did he give you any reason why he hadn't come around since the year 2017 or no?
Yes, he did.
What was the reason that he gave you?
He said he was involved with an individual that had dealing with drugs, and they had threatened the family, and so for our protection, he wasn't allowed to be around and communicate with the children and myself, and that they had police surveilling our home.
Has Mr. Olivas threatened you in any way since the case was filed?
Yes.
In what way has he threatened you since the case was filed?
He tells me that I'm gonna go to jail and that I'm gonna lose my children.
Ma'am, I'm going to show you what's been marked for identification as P9, P10, and P11. Generally, ma'am, what are these documents?
There's text messages between George Olivas and myself.
Do you regularly communicate with Mr. Olivas via text messages or no?
Yes.
Do you have any reason to believe that anyone else other than Mr. Olivas is communicating with you in these messages?
No.
Are the messages contained in these documents true and correct copies of the messages contained on your phone?
Yes.
And have any alterations been made to these messages?
No.
Your Honor, at this time, I move to admit P9, P10, and P11 into evidence.
Any objection?
I would object as to relevance, but I don't understand exactly why we're discussing these.
Ms. Doe, looking at P9 on your screen here, what's the date contained at the middle of the page here?
July 6th of 2020.
And was Mr. Olivas on this date trying to see the children or no?
Yes.
What does he say here, or does he say there at the bottom of page 1, generally regarding the Garland Police Department?
Sorry, I'm trying to figure out how to.
No, go here. This your idea. Okay. Go here. There you go.
Take your children.
Okay. On the second page, does he say anything about you potentially going to jail or no?
Yes, pretty much with going higher and trying to get me in trouble for that incident, yes.
Okay. And then on the fifth page of P9, what is he saying here generally?
He tells me that there is breach of contract, there is no evidence. Yeah, and so he'll send me notices and stuff for breach of contract.
Are these more legal threats against you or not?
Yes.
And on page 9 of P9, what is he saying about me, your attorney?
He says that you're not licensed to practice law.
Okay. And is that the same thing on page 10 or no?
Yes. Thank you.
And on the last page, page 13, is he saying that you were trying to take the children from him or no?
Yes.
Man, let's look at P10. At the top of the first page of P10, what is he saying here?
He tells me that that I'm harming the children and that he has done nothing wrong.
And continuing from the first page into the second page, what is he asking you to do generally?
He wanted to talk to me.
What was your understanding of what he wanted to talk to you about?
It was about the lawsuit of the court.
And at the bottom of the second page of P10, he claims you don't care for the decree. But man, has he followed the decree for the last several years or no?
No, he doesn't.
In January 2021.
Yes.
And were these conversations that took place made voluntarily and in good faith without any inducement?
Yes.
Have any alterations been made to these recordings?
No.
Your Honor, at this time, I have moved to admit P6, P7, and P8 into evidence.
Any objection?
Any objections?
Again, I would say the relevance of the matter because nothing has been disclosed. But
Yeah. witness that we knew.
Straight all the way back.
Just testing. Can everyone hear that? Yes. Okay, thank you. I'm going to play a portion now of P8 for you.
You're going to modify what the original petition was, and they have good judge that wasn't actually play in the law at all. I've been on the different other motions, and he's gonna have to prove the original jurisdiction. He's gonna have to prove whether he's actually acting against the judge or not, and he'll be liable for that. I don't know what that will show, but it's essentially gonna get thrown off the stage. It'll get a new judge, an actual judicial judge, and then the enforcement clause that are coming into play.
Yeah, what is he saying about the judge here generally?
Pretty much that he's not acting according to the law.
And which judge is Mr. Olivas referring to here specifically?
Judge Buchanan.
Okay. Play another portion of this for you now.
Was anticipated that you follow through on what you decided was best for the kids. You have not been following that. That is why I got a lawyer in to help us fix the situation. And I'm just gonna leave it at that. And I don't want to sit here and have you tell me again, George, let me talk, please. I haven't interrupted you. I let you talk for like 20 minutes. Please. Trying to get this, George, stop. I'm trying to get this fixed. What's best interest for the boys? The decree you have not followed the decree for years. That is why I have the judge to help.
Ma'am, what are you telling Mr. Olivas here in that portion of the recording?
That pretty much, I want help from the court, the judge, to help modify the decree because that's not what we've been doing, and I want what's best interest for the children.
Okay, and ma'am, I'm going to show you P10 one more time here. Is it common for Mr. Olivas to ask you to tell him what you did wrong, or no?
Yes, all the time.
Is that contained in the first message here on top of P10?
Yes.
Ma'am, when Mr. Olivas started coming around again in the year 2020, was he on time to see the children?
No.
Would that happen on just one occasion or on several occasions?
All the time.
When you say all the time, how late would he be in seeing the children?
It varies. There's been times 7, 8 o'clock.
And what was this time he was supposed to see the children? Do you recall?
6 o'clock.
Okay. I'm going to play you another recording now, P7.
Do something, babe.
I'll play
Say
a
something.
portion of this as well.
Judge, if I may ask a question.
What's your question?
I'm not sure at this point. Well, you said not to comment or interject while they're speaking, so I'm just trying to figure out, do I then get the chance to ask her questions to figure out whether what she's saying is truthful, or do I need to object while she's saying something if something is not correct?
No, you'll get your opportunity to cross-examine her, but right now, she's on the witness stand.
Okay, that's all I need to know. Thank you.
Thank you.
Mister, I'm going to play you a portion of P7.
Disclaimer says we like to record everything before So, we want to understand, and the boys also want to understand how everything that's going on right now is beneficial to them.
What do you mean?
Explain it to them, they don't get it. They don't get it. They say they don't get it. The only answer they've gotten from you is that...
George, you know that we are not supposed to talk about this to the boys, so...
Ma'am, what did you take this statement that the boys want to understand court? That statement by Mr. Olivas, what did you take that to mean?
That he's been discussing the litigation with the boys.
Okay. He also goes on to say that the children are your judges. Were your children there during this recording as you talked with Mr. Olivas?
Yes.
Who was it between you and Mr. Olivas who brought up talking about the litigation during this conversation?
Mr. George Olivas.
Another portion here.
In their life for over almost 2 years. Answer that. Were you involved in their life?
On orders, no.
Have you provided for them? Have you given them any money for school stuff?
I gave you plenty of money for several years. Sorry, everyone. Hold on, one moment.
Sorry, everyone. Technical difficulties.
Can I ask for completion's sake for him to play the rest of that clip he was just playing?
Okay, sorry.
For completion's sake, can I ask for him to finish playing the tape he was just playing?
Your Honor, my headphones just died on me, so I had to switch to my computer's speakers. So I was in the middle of playing and it cut out on me, so I'd like to finish playing what I was playing. Okay.
After we had the wars, and I concluded with your text with the charge me stuff. I was not obligated to give you any money, but I set you up so that you could move on with your life.
Okay.
Have you ever given me money?
Ma'am, did you hear that portion of the recording?
Yes.
What is Mr. Olivas saying here?
That he has helped me out financially in the past, and he asked if I in turn give him money.
Okay. We're going to play you an initial portion of this recording.
You sent these to us.
I decided to make modifications based on what my boys asked.
That's what's in the best interest of the boys.
So did I do something wrong when I decided to leave on you?
No.
Okay, is that what you're saying though?
But you haven't helped me at all. You weren't involved in the boys when I first heard them cry.
Let's say that someone steals a body, right? And then you find out that they stole your money, right? They took their money and they said, you know what, I'm giving back your money. You should pay me for the 8 months I had your money.
Have I did that to you?
Did you take the time that could have been with me when you asked for it and went it with you and now you want to penalize for it and sign it for child support?
You allowed them to come over. I didn't
Now
say
you want to
anything.
penalize for it and sue me so you can pay child support?
No.
That's what you people would say.
What does Mr. Olivas say here with respect to leaving the children with you?
So pretty much, since the children were in my care, and now that I'm asking for assistance, or changing the decree, he's saying that now he's pretty much being punished, because I'm asking for the help and assistance.
We're playing one last portion of P7 more.
It's threatened by a hotel. It's
So how am I supposed to know?
because they actually investigated
For
me.
safety reasons, I
Who says you were there?
apparently told you how to get it.
The PA had the surveillance. The PA, narcotics department had the surveillance.
And we thought this is going nowhere.
No, I'm asking you how you're threatening and saying that I'm doing all these things and you're making all the allegations with no proof.
nothing to do with
Have I ever hurt you?
The three things have to listen, nothing with.
Because I agreed that it was a very best interest at the time. At the time.
Okay.
I didn't know you were going to sue me and do all this other crap.
No, if you had take up your responsibility
So
as
was it a
God.
bad decision on my part to even with you?
No, because I told you.
It wasn't a bad decision. Okay, now it is though.
No, because you stopped helping out at period.
Was it a bad decision to even with
Answer
you?
the question. Have you stopped?
I was ordered to. I was ordered to stop. Going over there, fighting the air because of what happened with me. I had no control over that.
So you have proof that they gave it to the stop coming and communicating?
I had to stop it after
Do you
they said.
have proof? That is
Something
exactly.
Now, does Mr. Olivas admit to leaving the children with you in this recording?
Yes.
Does he say that he was under orders from the DA?
Yes.
To do what?
To stay away from us.
And has Mr. Olivas to date given you any documents proving that?
No.
Ma'am, has Mr. Olivas mentioned anything about why he was unable to reach out to you during the period of time he was not coming around in 2017? Or no?
Yes. Dealing with the cartel thing that he had mentioned. And
Did you have a way to contact him?
Him directly, no.
Did you change your phone number during this period of time?
No.
Did you change your residence during this period of time?
No.
Now, during this period of time, when Mr. Olivas was not coming around, did Mr. Olivas send you any money to help with child expenses?
No.
Ma'am, I'm going to show you what's been admitted as P11. Are these messages from November of 2020?
Yes.
What is he saying to you generally on the second page here?
He asked me if you were aware of everything, and then if not, and then also he wanted to disclose a situation with my stepdad.
Okay, so what is the stepdad situation?
My stepdad, he is a registered sex offender.
Okay. When did that incident occur? How old were you?
I was probably about 12.
And how old are you today?
I am 30.
As of today, does your stepdad come near the children?
He does.
Are the children ever left in his care without you or any adult being present?
No.
Ma'am, on the fourth page of this document, generally speaking, what is he saying in this text here?
Pretty much that I'm trying to take the kids away from him.
Is he saying anything that you're thinking that he abuses drugs?
Yes, with that. Dealing with that, yes.
And why are you concerned about any drug use by Mr. Olivas?
Because he said that he had dealings with the cartel situation.
How did he get involved with the drug cartel to begin with, if you know?
He said he met this individual at work.
Okay. And did Mr. Olivas say anything about drugs being left at his apartment, or no?
Yes, he did.
When was that statement made?
When he first explained to me why he wasn't involved in those 2 years.
Now I want to shift focus now to the recording from January 2021. Is this the recording admitted as P6? I'll play you a portion of this.
I have school this week, George.
They're going to have school this upcoming week and they don't want to go with you, so
George, you can't refuse to let them go.
I'm not refusing to them, so they don't want to go with you. Just like when I went to go pick them up with you and the cop said it was a civil matter, and if they don't want to go, they don't want to.
No,
That same thing applies here.
But that time you hadn't picked them up in a long time. You didn't even know this. I know this was just by me.
If you want to do it, call the cops. Go ahead and call them. The cop is going to ask you two questions. Two questions. Are they going to do it? I'm going to go through them over again. Okay, look at it. And they're going to have
But you're talking to the boys about litigation. That's why you're doing
conversation in January of 2021. Is he letting you speak to the children?
After a while, he did.
Okay. They play you a portion here.
No.
You don't something good. I got the whole thing on video. I took the whole video of the whole court.
And you showed it to the
Of
court.
course. That's four that showed up in my name on there. They got it. That's why they're not okay with going with you.
No, you're doing this and that.
Ma'am, in this little portion, did Mr. Oliva submit to taking a video of the court proceedings?
Yes, he did.
And did he admit to allowing the children to watch a video of the court proceedings?
Yes.
People look for the lies you told the court.
I haven't told any lies. I told them I didn't really know the truth and you know the truth.
Yeah, they want the point of it. They know the truth. They want all of it.
One moment.
I got everything on video.
Yes, Your Honor.
Olivas, recordings are prohibited. I see your family members sitting back there with their phones held up. They'll need to exit the room, all of them.
The reason for the recording was because when I asked for the original hearing, when the original...
I don't care what the reason was, it's prohibited. So all of them need to leave the room.
They have cups of coffee, they're not phones.
All of them need to leave the room.
Is there a reason why I can't have a witness here?
Did you just hear what I said, Mr. Olivas?
Yes, but none of them are holding the phone.
I want all of them.
Use the video to show the kids the video recording of the court proceedings?
Yes.
You understand that you're not doing it. They don't agree with you. That's why they're doing it. They don't agree with what you're doing either.
You're not supposed to know adult situations, kid.
Adult situations, you try to get them to testify in court. Behind those doors to a judge when you want to lose. That's how they have repercussions of it. So don't
They requested the interview. Lord, please. Please. Lord, please.
They want to stay here.
No, it's not. No, I'm not talking to you, okay?
You want to go and stay wherever you stand.
George, stop.
And she has to decide whether she lets you in or not.
Man, is Mr. Olivas in this portion of the recording telling the children that they don't have to go to Florida?
That's correct, yes. Right now.
Why are they too friendly? They're trying to go ahead and protect us.
What are you doing there? Let me talk to police. This is my relationship with them.
They don't want to go.
Now, because of what was said in this recording, what appears to be respect to what Mr. Olivas was telling the children?
Their mental health, is not a situation that their kids, like some kids who had, and also their relationship with my house.
How do your children act towards you currently?
It's been difficult. With my family, we're good. Our relationship is pretty good, but with my younger one, it's been a struggle. He doesn't really talk to me as much. He lashes out a lot, and he's just very angry.
During the start of this case and today, how else has it been changed?
He struggled with school. And his attendance, school attendance, he was doing remote learning, his attendance was really bad as well. But emotionally and everything else. Like, there's a big difference in Ruben, especially.
Have you been able to have possession of the children consistently since December of 2020 or no?
No.
Now I'm going to show you what's been marked for identification as P4 and P5. Do you see these two documents on your screen?
Yes.
And would these exhibits assist you in testifying as to how often you had possession of Ivan and Ruben for this year, 2021?
Yes.
Do these documents reasonably depict your possession time with Ivan and Ruben?
Yes.
And is that for the time period of January through July of 2021 or no?
Yes.
Your Honor, at this time I move to admit P4 and P5 in evidence. Any objection?
As to authenticity or verification, yes, I object to them.
Overruled. P4 and P5 are admitted. Now I'm going to start with P5. Is this the document that shows your possession time for Ivan in 2021?
Yes.
Now, just so the court can follow along, are the highlighted weeks the weeks that you are supposed to have a given child or no?
Yes.
And further, in any of the markings with stars or asterisks, are those the periods that you actually had your child or?
Yes, that's correct.
Okay. So looking in January for Ivan, did you have Ivan for all of your ordered time or no?
No.
And looking in February, how did you have Ivan in February of 2021?
Regularly.
The Friday the 5th through the 12th?
Yes.
Was that a week that you were supposed to have Ivan or not?
No, but because he missed that 1 week, they had COVID, so I didn't want him to stay to make up the time with me on that week.
And for March, how much of March did Ivan stay with you?
The majority.
For April, how often did Ivan stay with you?
The majority with Dad's permission.
And for May of this year, how often was Ivan with you?
It was on my regular schedule.
And for June?
Same regular schedule.
And for July so far?
When we got together in 2017.
Now I'm going to show you P4.
When I uploaded them to
P4. Is this for Ruben?
Yes.
Did you have possession of Ruben in January?
No.
Why not?
Dad tells me that he refuses to go.
Okay. And in February, did you have possession of Ruben?
I had him for a little bit, yes.
What about in March of this year?
None.
In April of this year?
1 month.
In May of this year?
None.
In June of this year?
1 month.
And so far in July of this year?
He's been home so far in July.
And in comparing between Ivan and Ruben, who did you have possession of more in 2021, Ivan or Ruben?
Ivan.
Have you asked Mr. Olivas throughout this year, do you have your time with your children?
Yes.
And what has been his response if you have to summarize it?
He told me that he doesn't want to go unless I drop everything.
In your opinion, have your children changed in their demeanor in any way since the hearing in December of 2020?
Yes.
In what way?
With my older son, he's a lot more reserved. He has expressed feelings of depression and sadness, irritable, and yeah, for Ivan and Ruben, again, he school-wise has been really big, but emotionally, I can tell just by the interaction with him, he's very detached. He's very angry, and he starts fights and things a lot, and he takes that, cursing, lashing out. and things like that.
Do you believe they need counseling?
They do.
What makes you believe they need counseling?
And to help with their mental and emotional health, as well as their relationship with myself and each other.
Prior to this current case, how long have the children been in your care?
Only myself, 2017, but primarily 2013.
Okay.
Make sure you bring out the part where Ruben tried to kill himself. Like, on her.
Lose time with your children this year in 2021.
You have to bring all that up.
Has Mr. Olivas, for refusing the children to you, caused you to incur additional attorney's fees?
Yes.
Did you file discovery requests against Mr. Olivas on January 19th, 2021?
Yes.
Now I'm going to show you what's been marked for identification as P12. Is this document a true and correct copy of the discovery request served on Mr. Olivas?
Yes.
Have any alterations or changes been made to this document?
No.
Your Honor, I move to admit P12 into evidence.
Any objection?
The only objection is that I sent him discovery and he has it, he received it, I can verify it, but he's not admitting that part.
Overruled. P12 is admitted. Now, contained within this document, did you ask for Mr. Olivas to respond to request for disclosure?
Yes.
Did you ask for Mr. Olivas to produce documents in response to a request for production and inspection?
Yes.
Did you ask for Mr. Olivas to respond under oath to written interrogatories?
Yes.
And finally, did you ask for Mr. Olivas to admit or deny certain matters in response to a request for admission?
Yes.
And within 30 days after Mr. Olivas was served with his discovery request on January 19th, 2021, did Mr. Olivas respond?
No.
I'm going to show you what's been marked for identification as P13. Do you recognize this document?
Yes.
Is this document a true and correct copy of the letter that was sent to Mr. Olivas on March 30th, 2021?
Yes.
Have any alterations or changes been made to this document?
No.
Your Honor, I move to admit P13 into evidence.
Any objection?
No.
P13 is admitted.
Ma'am, in essence, did Mr. Olivas respond to this letter by April 6, 2021, or no?
No.
Did Mr. Olivas last month in June of 2021 respond at all to the discovery?
Yes.
Was a hearing held in front of Judge Beecham in May of 2021?
Yes.
Was it on a motion to compel discovery, among other things?
Yes.
Was Mr. Olivas, as a result of that hearing, ordered to respond to the discovery request by June 11, 2021?
Yes.
To the best of your knowledge, did Mr. Olivas respond to the discovery request at all?
He did.
Was there a problem with it?
Yes. He objected when he was no longer allowed to.
Now, to the best of your knowledge, has Mr. Olivas filed any kind of motion to withdraw or amend the deemed admissions?
No.
I'm going to show you what's been marked for identification as P14. Does this document fairly and accurately summarize the original request for admission? And would this document aid you in testifying what is deemed admitted by Mr. Olivas?
Yes.
Your Honor, at this time I move to admit P14 into evidence.
Any objection?
Yes, that document does not reflect the actual discovery he received.
Overruled. P14 is admitted.
And ma'am, just generally, I'm going to ask you a couple of questions about some of these the deemed admissions. Ma'am, according to this, has Mr. Olivas voluntarily relinquished actual care, control, and possession of the children to you for at least 6 months?
Yes.
Should you have the exclusive right to make decisions for medical, mental health, education, and school enrollment for the children?
Yes.
According to this, should Mr. Olivas have possession of the children with no overnight visitation?
Yes.
he should have possession of the children with no overnight
Judge,
visitation.
I'd like to object on Mr. Conacher testifying instead of the witness actually telling her what she needs to say. Mr. Conacher is using the questions as a way to testify instead of the witness actually.
Okay, sustained. Okay, ma'am, what does this first sentence next to number 5 say?
Objection. He's leading the witness.
Overruled. You can answer the question, ma'am.
It says respondent should have possession of the children with no overnight visitation.
Okay. And what does the first sentence next to number 7 say?
Again, objection. He's leading the witness exactly to the answer he wants to get out of her. You can't lead the witness. You can ask a question, but it's not a question.
Overruled.
Respondent should be ordered to pay child support to not adult.
Okay. And in the interest of time, ma'am, I'm going to move on. Were you previously asked by this court during this litigation to complete a co-parenting class?
Yes.
I'm going to show you what's been marked for identification as P19. Do you recognize this document?
Yes.
This is documenting true and correct copy of this certificate of completion with no parenting class.
Yes.
Have any alterations or changes been made to this document?
No.
Your Honor, I need to admit P19 into evidence.
Any objection?
No.
B19 is admitted.
In sum, ma'am, what kind of a possession schedule should Mr. Olivas have with respect to Ivan and Ruben going forward?
Standard visitation or whatever the judge deems reasonable.
That calls for a legal determination on Rhonda's part.
Sir, please do not interrupt. Mr. Conacher?
Ma'am, are you asking the court to grant all the relief requested in your summary of requested relief or no?
Yes.
Are you asking the court to grant your proposed parenting plan?
Yes.
And, ma'am, what kind of health and dental insurance are the children on currently?
They're on Medicaid.
And do you have any health and dental insurance available to you through your employer?
I do.
Do you have any idea what the cost of that is each month for the children?
Not 100% no.
Would you be able to afford it if you were to put them on your health and dental insurance available to you or no?
No, not from what the last time I saw the rates were, no.
Okay. Are you asking the court to make orders in the best interest of your children?
Yes.
And to make orders for the safety and welfare of your children?
Objection. Again, he's testifying during the questions.
Overruled. Just to be clear, are you asking the court to make orders for the safety and welfare of your children?
Yes.
No further questions, Judge. Pass the witness.
Okay, is Miss Sigmund? Miss Sigmund?
Judge, I just heard that she has medical insurance through the government.
Yes.
State would be requesting at least $100 cash medical.
Okay. Okay. And you may ask questions of Ms. Doe.
I'm sorry, what? Were you talking to, may I now question the witness?
Yes.
I'd like to refer to the, one second, let me pull this up. Can I share my screen? May I share my? Rhonda, did we agree when we got separated exactly what it was that we were going to do as far as custody goes?
Ready?
Okay. Do you?
Are you asking me if we agree?
Yes. Did we have a conversation and agree exactly what we were going to do with the custody of our kids?
Initially, no.
Do you remember writing to me? If you can see the screen, this letter here, and this is just to show the intent. It's not necessarily to testify anything.
Yeah.
Okay. Can you summarize, what you were saying in this letter here?
What's the topic of this letter? I'm sorry.
This is just to show the intent of how and why the agreement came about and what she herself was supposed to agree to.
When are we talking about?
Right before the agreement happened. This is just to demonstrate that she
Right
had
before what agreement?
the divorce decree.
We're past that, sir. We're on application.
And I'm going to object because it's reaching behind the divorce decree code.
Okay.
Sustained.
She just testified that she did not know that, or we did not have an agreement yet. This is a document that shows, that she signed it.
Your Honor,
I'd like to.
He's testifying. He's not asking questions of the witness.
Sustained.
Rhonda, do you recognize this document that I'm showing now?
Yes, I do.
Do you recognize your signature at the bottom of this document?
Yes.
Okay. Does this look familiar as far as the pre-agreement?
Sir, that's irrelevant. We're only talking about it's stuff from after the final decree till now. That's it.
And I will object to relevance and reaching behind the divorce decree code.
Okay.
Sustained.
Rhonda, did you read the divorce decree?
Yes.
Do you understand the divorce decree?
Yes.
If you've read and understood the divorce decree, what are your duties and responsibilities under the divorce decree? Primarily.
I take care of...
As a conservator.
What was that?
Your responsibilities as a joint managing conservator, do you know them?
I don't understand the question completely, but we're co-parents and I take care of the kids on my end and you take care of the kids on your end.
Okay.
In all aspects on our weeks.
Did you sign the agreed joint custody agreement willingly?
Objection, relevance, Judge.
Sustained.
Was the agreement a decision between you and me, and did you agree to that decision?
No. Objection, relevance, Judge.
Sustained. Sir, again, we are not talking about that. We are talking on her modification.
Well, the modification has to be based on a read. There has to be a cause of action for the modification. I'm trying to figure out what that is.
She's just testified to what it is.
She did not testify as to me doing something to her.
Okay. Do you have any other questions?
Yes, I'd like to know if she understood the divorce decree, she read the divorce decree, and she knows the terms and conditions of it. Why did you file a modification in 2011 immediately after the divorce decree was signed?
I didn't file anything. 2011, I didn't file anything. The first thing I filed was 2020 with Mr. Conacher.
I'd like to admit this piece of evidence, and it's what I received from the court as far as the events on the case. And do you see what it says at the very bottom, or right around 12/01 of 2011?
I'm going to object. He's reading things that are not in evidence yet.
Sustained.
Am I able to admit a docket sheet summary of the case?
Sir, I can't tell you what you're supposed to do. You're held to the same standard as an attorney.
I'd like to admit this docket summary of the case as evidence.
And I will object, like Shakespeare say it's not authenticated and it wasn't produced in discovery then.
The same?
I'd like to understand you're holding the attorney up to a different standard than you are myself.
No, I'm holding you to the same standard as I'm holding him as an attorney.
He did not provide discovery. I requested it multiple times.
Do you have any other questions?
Yes, I'd like to figure out what were rules of evidence or what we're going off of here, because you're not lending the same being unbiased. You're completely siding on the side of the attorney. You joined the prosecution.
There is no prosecution there, sorry.
You joined the opposing party, and you're
I
aiding
haven't
me.
joined anyone.
You're not letting me give my testimony.
Do you have another question, sir?
I'd like to understand why you've allowed.
We're not here for a teaching lesson. Do you have another question?
The voices lawyer in litigation.
Can I make an offer of proof?
You know how to do that.
May I have leave of court? I'd like to make proper answer to the court if I'm not going to be able to testify. You're trying to rush me to judgment here.
Denied.
Would you reveal based on what ground that was denied?
No. Do you have another question?
No, I don't. You've
Okay, Mr. Conifer, next witness.
Yes, Your Honor, I like to call Ms. Diane Zilka at this time.
Okay.
Good morning, Ms. Zilka. Can you hear me?
I can, good morning.
Am I saying your last name correctly?
You are?
Okay, good. Ma'am, would you please state your full name for the court?
It's Diane Zilka.
And ma'am, what is your current position?
Stop short your
I'm a
screen.
family court counselor.
You
with
need
Johnson
to
County Family Court
focus
Services.
on the decree and where it says that she needs to let you know before she sues you.
And were you court ordered to do a child custody evaluation in this case?
Yes, it was.
And how long
And that she
have
needs
you
to
been
pay
doing
for her
custody
own
evaluation?
attorneys. Do you have a contract?
Since
Yeah, no, let me
1998.
hit that.
In this case, you recall who started
Okay,
this
it's
child
not the same
custody
thing.
evaluation?
And she's not letting me question.
My initial interview was on March the 2nd of this year.
And has that child custody evaluation been completed?
Yes, although it was a partial evaluation.
I understand. Is your report contained in what's been marked for identification as P18?
Yes.
And okay, and ma'am, have you had a chance to review your report prior to today?
Yes.
Is that what's contained in what's been marked for identification as P18 a true and correct copy of your report?
Yes.
Have any alterations or changes been made to this document?
Not that I can tell.
Is that your signature on the first page?
Yes.
And is that your signature on the 18th page of this document?
Yes.
And at this time, Your Honor, I need to get P18 into evidence.
Any objection?
No.
P18 is admitted.
Ma'am, on page 18 of the PDF, page 17 of your report, can you summarize each of your recommendations for the children in this case here?
I recommended family therapy for mom and both children. I recommended that if the court determines that the father is disparaging the mother to the boys, as the mother alleges, and as I've reported, that there should be measures taken to stop that. Those measures could include something like limiting dad's time with the boys, requiring him to take a co-parenting class, or even individual therapy for him. I recommended that both boys attend and receive annual medical checkups and routine dental checkups and regular follow-up with any medical issues that they may have, including medication management for them. And I recommended that both parents make a plan with the school to better support the academic.
Okay. And then you mentioned with respect to family therapy, can you give some more reasons for the court why you believe family therapy is recommended for the mother and both the children in this case?
Well, there's significant disruption in mom's relationship, particularly with Ruben. I was not able to interview Ruben because it was not provided to me. However, based on mom's statements and Ivan's statements, there seems to be a significant issue in their relationship. And that represents a significant change from the past.
Absolutely. And you mentioned individual therapy for the children. Can you explain to the court why you recommend individual therapy for the children in this case?
I think individual therapy for children is always intended to give them a voice, to give them a place that is safe to discuss feelings about both parents. When it's not, they don't have to have an allegiance to anyone, or it's just a safe space to express themselves. And I think in this particular case, individual therapy would also help them to kind of better understand maybe both the parents' behaviors and points of view, and help the kids to sort of distinguish their own feelings from that of their parents.
Now, would it surprise you to learn that Ruben was prevented from being with Miss Doe and Mr. Olivas, or no?
No.
Would it surprise you to learn that of the two children...
Objection. He's testifying for the witness.
Ma'am, would it surprise you to learn that of the two children, Ruben is the one struggling in school, or parents Ivan or no?
No, that's exactly what the school records show.
I want to actually talk about that. I want to go to the 59th page of this report. Is this a school information form at the top?
Yes.
Which child is this for?
For Ruben.
What's the name of the school for Ruben?
Hudson Middle School.
And on the same page, under item 1 in the comments, what is mentioned here? It's
a grid asking for sort of the school's opinion about the student. And what they've written was that he attends, but he shows up late often.
Okay, and below this box, under please check the appropriate descriptive items related to this child, what is contained here next to comments?
They just commented that at the beginning of the year he was actively involved in this school and participated frequently, but now it is difficult to even get him to participate in a minimum kind of way.
Then next to enrollment dates at this school, what does it say here?
From August of 2020 to June of 2021.
Now, ma'am, on the next page, page 60 of the PDF, what is contained here next to number 2 with respect to Ruben's academic performance?
That his academic performance has declined over this semester, but that he's a very capable student.
And when this page says this semester under item 2, what semester specifically is this referring to here?
The second semester of the last school year.
Okay. At the bottom of the 60th page here, what is generally being said here about Ruben's performance between the two semesters?
That he used to be engaged in his learning. He had his camera on for virtual school and was answering questions and asking questions. But that now, at the time that the teacher signed it, she was having to ask him multiple times to turn on his camera or answer questions. He was a very solid A student in the first semester, and he was, at the time she would fill that out, he was failing the classes.
We'll turn to the 64th page here now. Who is, I'm probably saying this incorrectly, Yasmin Tajani?
Dr. Tahani is the boy's primary care physician.
Tahani, okay. And you said it's a children's pediatrician, is that correct?
It's a primary care physician, that's true, pediatrician.
Now, what does this pediatrician say about Miss Doe in the first full paragraph here?
She says that the mother is the only parent that she had seen, and that she was feeding the boys consistently, and she was a very conscientious parent.
And what about in the last full paragraph here?
She expresses an opinion that mom is doing a wonderful job as a parent, and that she has been essentially a single parent for a number of years.
Okay. Ma'am, did Mr. Olivas cooperate whatsoever with his child custody evaluation?
No, sir, he sent me 2 emails.
Okay. Did he sign releases to enable the receipt of relevant records?
No, he did not.
Did you express any concerns about Ms. Doe's ability to provide a safe, loving environment for the children at all?
I'm sorry, did he express that?
I'm sorry. Did you, in your report, express any concerns about Ms. Doe's ability to be a parent for the children?
The only concern that I have about mom was that there was a member of her family who's a sex offender, registered sex offender.
Okay, and I'm going to go to that portion here. I think this was the portion here you just referenced. With respect to that, did you come to any conclusion with respect to this individual or no?
I guess I did.
Then what would that be?
The conclusion I came to is that this is a situation that has occurred prior to the boy's birth, prior to the parents dating or marrying, and that this person is not present in mom's household. And in fact, the victim in that case was mom's older sister.
Okay. At the bottom of page 15 of your report, you mentioned that Ms. Doe reported that Mr. Olivas did not have contact with the children for 2 years and then suddenly resumed the 50 schedule. Is that an accurate reading of what you wrote in your report?
Yes.
In the first full sentence at the top of page 16 of your report, it's the scene of the PDF of your report. What do you say here beginning with, if true?
I said, if true, this kind of sudden significant change does not appear to reflect the boy's best interests and likely represents some other agenda on the part of the public.
I have no further questions, I'll pass the witness.
Okay, Mr. Olivas, do you have any questions for Ms. Silka?
Yes, I do. Ms. Silka, what are the key questions the court asked for you to answer in regard to this evaluation?
There was no specific question on the court's order. In general, I'm guided by the tenet of child's best interest and the Holly factors.
When you evaluate a custody case, what recommendations are you able to give and what recommendations are you not able to give in regard to possession, access, or custody?
It depends on whether I have completed the basic elements written in the Texas Family Code. So in this case, since I was not able to complete the basic elements, I was not able to make a recommendation about conservatorship or access.
You mentioned that you in your report that you sent me the information for the initial for the Zoom meeting with you initially. What email did you send that to? The reason for the question is you mentioned that I had full knowledge of them, but I didn't ever get that. So I was just asking what email you sent it to and why it was not included in the emails at the bottom of the report.
I'm going to object to a compound question at this point, Judge.
Mr.
Why was the email not included at the bottom of the report that you submitted? That specific email.
I don't routinely include emails unless there's substantive information in them.
Okay.
So I included the email that you sent to me because you had mentioned substantive information.
Okay. Do you have that information as to what email you sent the other one to?
I can look very quickly.
please?
Could you please provide that email that you sent it to?
Okay, yes. You're correct. It was the wrong email. I sent it to jorgeolivas450@yahoo.com.
Okay. So in your report, you mentioned I had full knowledge of that, but you didn't send the email to the right one. Would you say that I had full knowledge of that event if I didn't have that?
Well, I sent a follow-up email the day after the orientation appointment asking you to call me to reschedule, which you did not do. So I would say you had knowledge, at least after the fact, if not before.
When it comes to...
Also, you should have received a letter in the mail. We mailed you a letter about the appointment as well.
And are you aware that Rhonda Doe paid for the evaluation as a whole, just her?
Yes.
Did I consent at any point for the evaluation?
Objection. Relevance.
The same.
Are you able to evaluate somebody who did not consent to your evaluation?
Yes, I do that routinely.
And under your licensure, is it ethical for you to evaluate somebody that you had no contact with?
Yes, the information that I provided is ethical, yes.
Did you at any point make observations about my mental health or the way that I carry myself without you evaluating me or having a personal interview with me?
No.
May I share my screen?
You may.
Ms. Silka, did you at any point verify the contents of what Rhonda Doe told or gave you as information?
I reviewed as many records as I could.
And as to Rhonda Doe's statements in the interview, did you verify anything for that?
To the extent that it was possible, yes.
Okay. Did you make any recommendations or observations based on specifically what she said?
Not sure I understand your question.
The statements that she made to you, is there a way that you verify those type of statements at all, or can you just is there a way to verify that at all?
There is, and I asked people to sign releases of information so that I could get records to substantiate the statements that were made. It would have been much easier for me in this case if I had moved to sign the releases so I could get more full records. But yes, I did do that to the extent it was possible.
From the records you pulled, did you include any reports in here for those records?
I included the ones that weren't covered by another statute. I'm prevented from attaching records that are protected by some other statute.
What would be a protected record when it comes to other children?
Comes to other children. The protected statutes that I generally run into are things like anything that's protected by HIPAA, medical records, counseling records, things like that, or police records are protected by the Texas Government Code, or Child Protective Services records are protected.
Okay. So, are you able to comment on those records when they're protected? I'm sorry.
I summarized them in my report, please.
Okay. How do you verify those records if you don't include them on the report?
I don't understand your question. They're verified to me because I received them directly from the provider.
Okay. Kids that are not in the matter that you are evaluating, are you able to include those kids in the report?
Yes.
Even if they have to do with other cases, or you did not provide the record for those?
I interview those children if the parent is participating in the study. I am able to, under statute, receive CPS records that are pertaining to other children that are relevant to the family. And so I can talk about those in the report.
And
I'm not sure what other instance you may be looking at.
for the evaluation, how many times do you reference what Rhonda Doe says versus what you see from the information you're receiving as far as records go?
I don't have a number of times.
Are you aware that in this report, you can see the screen that I'm sharing? I highlighted just how many times past this point, how many times you reference the mother reported or the mother said. Is credit completely 100% given to the person that says one thing or another because they said it? Or?
No, certainly not. And typically I have two parents, so I can hear both parents' points of view.
Are you aware that in this report you mentioned Rhonda Doe reported or Rhonda Doe stated 134 times?
I did not have a number, but I'm not surprised to hear that.
When she talks to you about her concerns or so, how accurate does she have to be? Does she have to be when she talks to you about certain things?
I don't know how to answer that question, sir.
Okay. In instances where there's one parent claiming one thing but is not truthful, how do you verify that that parent is not doing that?
Well, it's typically easier if I have both parents because I can talk to the other parent to get his point of view about it. In this case, I did not have that opportunity.
In the report,
that I compare it to the records that I can find.
So would you say that you had no idea what my point of view was, or in any way, shape, or form?
That is true. The only point of view I know is that you said specifically that you were not going to participate in this.
When it comes to cases when there's child sex offender involved, what would be your system to evaluate whether that child is in danger or not?
Well, I interview the children, first of all, and try to make some kind of assessment about how present that person is in their lives and what kind of contact that person is having.
Would you say you normally child registered sex offender in order to ascertain that?
Only if he's a member of the household.
Were you able to interview her stepfather?
No, he's not a member of the household.
Did you verify at all whether he regularly visits the house, aside from just what she says?
I'm not sure what way I could have had to do that other than interviewing the parties.
Any questions as to his visitation schedule to the house?
Ask please.
The other members of the house?
Yes.
And you didn't include that in your report, so I'm not sure what they would have said.
I didn't include it in the report. I asked Ivan who lives in the household. I would have asked Rita too. I had an opportunity to do that.
Did you ask her stepmom, her mother and her brother at all? The other two adults in the house?
Yes, I asked them who lives in the household. Yes.
Did you make any further inquiry as to how often this registered sex offender visits the home?
Other than asking the people I had access to. I don't know how else I would have done that. Sorry.
Okay. In your report, you mentioned that, as you see on the page now, on page 5, you say the father is hateful and vindictive. The father actively seeks to alienate the boys from the mother, and the father specifically tells the boys that the mother's lying to them and that she's malevolent motives. What evidence do you have that I do that?
I know, these are me repeating what the concerns expressed about the father. So what mom said about you, I write in this section.
Okay. If I scroll down to the part where my son describes and talks about me, Would you say that my son Ivan accurately, or if he seemed genuine as he was talking about myself?
If he seemed genuine?
Yes. When you were interviewing, what did you observe of my son Ivan when he was talking to you about me?
I didn't have any reason to believe that he was not being truthful when he talked about me.
Did he mention negatively that I do or don't do anything?
Yes.
What were those things that seemed important to you that you mentioned about me?
He dislikes it that you are constantly talking to him about court things, and that you talk negatively to him about his mom.
Did he mention what I say about court things, or?
Yeah.
When you said that I talked negatively about his mom, in what way did he say that I talked negatively about her?
He said that you say bad things about her, that he tries not to listen to them, that he feels very stressed out when you do that he's exhausted and overwhelmed by it, and that he doesn't want to hear it.
Is that the extent that he said, or does that accurately reflect what he said?
Yes, and he also said that when he has asked you to not do that it has no effect on you, you just simply continue to do it.
Did Rhonda express from all your evaluation, did she express any positive points about my parenting?
About your parenting?
Yes.
No.
No positive points, not a single one?
No.
Did she in any way, shape, or form say that she actively works with me, or talks to me, or even gets along with me?
She said that she tries to co-parent with you.
In your experience, what would you say that looks like normally when somebody does do that?
Co-parenting?
Yes.
It looks like being cooperative with one another. It looks like communicating in a civil way. And it looks like supporting the other parent to the children.
Okay. Would you say that you see any evidence of that from Rhonda though, towards me?
I think that she tried to talk to me about my appointment with Ruben.
So, did you see any evidence of that though? Did you see her, did she show you any messages? Did she talk to you about talking to me in any way?
Yes.
And what did she say about that?
She said that she tried to talk to you about the appointment with Ruben.
You mentioned in the report that she says that I was withholding my son, but at the same time you say that my son, tells her he doesn't want to go with her. Did you ask her why he doesn't want to go with her?
Yes.
What did she say?
She said that he tells her that he won't go with her until she drops the court case.
You mentioned my stepson in this report for under CPS case. The way that you summarized it, is it the way that that's summarized in the report that you got?
CPS records are lengthy and repetitive, so I summarize them into a paragraph.
Okay. Do you ever inquire further into any of those reports?
Inquire, had I had opportunity to speak with you, sir, when I asked you about it.
And again, you didn't find any criminal history on me, did you?
I did not find any no, I did not find any.
From observing the court hearings that you do, or you have, I'm assuming you've observed at least 2 of them. Would you say that I'm a person that is difficult to speak to?
Yes.
Why would you say that I'm somebody that's difficult to speak to?
I would say that based on the emails that I exchanged with you.
Am I easily angered from what you can see and hear and observe?
I don't know.
Have you ever dealt with somebody who is being accused with no basis or foundation about the things that I'm being accused of?
Of course.
Normally, what is the way that that person handles this kind of matter? Would you say that that person is trying to assert a point? Or?
I'm gonna object to this point. It's hard to speculate. It's a very broad question.
Ms. Zilka, do you ever take the time to verify court orders?
I don't know what that means, sir. Ask me that before. I don't understand the question.
I'll rephrase. I'll switch off the question. Have I asked you for your supervisor's information, for instance?
You exchanged emails with my supervisor.
Who? I'm sorry. Could you tell me your supervisor's name?
Her name is Myra Kirkland. And my supervisor above that is Angela Egerson. I believe we've exchanged emails from both of them.
All right. And you mentioned prior that you don't verify those things. That goes to your boss, correct? Your supervisor.
When you ask me if I verify it, I don't understand what that means. I receive an order. I'm given a case that has an order in it, and I proceed with the case. I don't understand the word verify in that sentence. I'm not clear on what you want me to do.
Well, I would just, my question is if you received it, but you answered anyway. You said that your boss receives them and then they drop them down to you. So, are you aware, or did Rhonda tell you that this custody agreement was written by me in 2011?
Your Honor, I'm going to object. That's not relevant and reach behind the worst degree.
Sustain.
Last but not least, if there is a custody evaluation done and the other party did not participate, what is the recommendation at the end of that, and what are the limitations for that?
Your Honor, I'm going to object. That's overbroad and causes her to speculate.
Sustain.
So, I guess my final question to you would be: you mentioned here that I expressed concerns for this person, and then you mentioned that Rhonda basically stated what's on your screen now, her response and concerns. Did you investigate anything on that any further, or did you just take her word for it?
I did look him up in the sex offender registry.
And was there a recommendation given based on that?
Was there a recommendation?
Yes. Did you? Yes. On that matter, because you don't actually give a recommendation on it, you just say it's a concern. I just want to know why there's no recommendation on that.
I mean, I don't know what possible recommendation I could make since I didn't change that.
I'm not sure. That's what I'm asking you. Based on your evaluation, what is your observation from that fact?
Jack, ask and answer, Judge.
Sustain. Do you have any other questions of this witness?
No.
Okay. May she be excused?
Yes. Thank you, Ms. Zilka.
Okay, thank you, Ms. Zilka. You're free to go.
Thank you.
Okay, call your next.
I'll call myself for the issue of attorney's fees as an officer of the court, Judge.
Okay.
Your Honor, my name is Christopher Conacher, and I'm an attorney licensed to practice law in the state of Texas. I've been licensed to do so since November of 2012. At this time, I would offer P15 my resume and evidence.
Any objection?
Yes, I'd like to put into it. Yes, I object because that's not a license.
P15 is admitted.
Your Honor, I am familiar with the facts and circumstances of this case. I, together with other attorneys and staff at my firm, Warren and Ignacio, have performed various legal services for Ms. Doe throughout this case, including attending hearings, drafting and serving discovery requests, and preparation for and attending this final trial today. I have personally performed the majority of legal services for Ms. Doe in connection with this matter. My hourly rate for this matter is $325 an hour. I believe that fee is reasonable given my experience in the courts and the DFW Metroplex. At this time, Your Honor, I would move to admit P16, a summary of testimony regarding attorney's fees, and P17, the invoices for legal services provided for Ms. Doe.
Any objection?
No?
P17 and P14 are admitted.
I'm sorry, Judge, I think it's P16 and P17.
Oh, I'm sorry, P16 and P17 are admitted.
Thank you, Your Honor. I've spent over 50 hours alone in pursuing this modification case for Ms. Doe's behalf, and attending various hearings and preparing for final trial. I'm asking for a total minimum amount of $16,250 as reasonable and necessary attorney's fees. The full amount of attorney's fees that I'm asking for today is a total of $22,342.37. The fees were unnecessarily increased due to the litigation strategy implemented by Mr. Olivas, specifically Mr. Olivas, in this case, by trying to have Judge Beecham recused. Mr. Olivas also refused to participate in a child custody evaluation, and Mr. Olivas further delayed this case by refusing to allow one of the children, Ruben, to participate meaningfully in that evaluation too. Mr. Olivas has ignored the discovery request I served on him, which Judge Beecham had ordered in the ensuing motion to compel discovery hearing in May of this year, for Mr. Olivas to answer and produce the documents requested without objection by June 11th, 2021. He then answered the request for admission and several other of the discovery requests with objections, and that was nearly 4 months late for the due date. His tactics has caused a delay and hindrance to my ability to effectively prepare this case for trial. I believe that these requested fees are reasonable and necessary given the facts and circumstances of this case, and I pray that the court award these attorney's fees against Mr. Olivas, together with post-judgment interest. I pass myself as a witness. Thank you, Judge.
Mr. Conger, are you aware of the contents of the divorce decree from 2011 and the fact that it's a joint custody agreement?
I would object, Your Honor. I have relevance to the issue of attorney's fees.
Ms. Spain?
Well, the relevance is, if I may share my screen at this point so that I could have him answer the question.
I've already sustained the objection.
Well, then may I make an offer of proof so that so that I could put it on the record that, may I share my screen?
Sure.
Thank you. In making my offer of proof, I'd like to point out that in the divorce decree, the matter of attorney's fees is touched upon, and it very specifically mentions that any further litigation be.
He's testifying. He's not asking any questions.
Yes, I'm making an offer of proof.
That's not how you make an offer of proof, sir.
Mr. Conacher, the attorney's fees you say that were valid, how would you justify some attorney's fees when the lawsuit that you filed was frivolous and had no basis in law and fact?
I disagree with your assertion, sir, but I justify it because I believe after interviewing Ms. Doe and talking to her that a modification was warranted and is in the best interest of the children, hence why we're here at trial.
Did you make any sort of, or did you look into the matter and verify that what she was saying was enough to get you involved in this case?
I'm not sure what you mean by looking into.
Did you do your due diligence and investigate as to the matter?
I trust Ms. Doe and what she is telling me. And that's why I recommend her to the best of my ability to not only for her, but for the best interest of the children.
The attorney's fees you say are justified. You mentioned that I never asked for discovery. Do you recognize, and can I admit, and I'd like to admit this initial answer after the lawsuit to the court as my answer. Did you read this, Mr. Compton?
First of all, Judge, I'm not sure if he's offering this as evidence, but I would object that one, it's already part of the court's record, and two, relevance to the issue of attorney's fees.
Well, the court. You mentioned that the attorney's fees were necessary, but what was the cause of action, Mr. Conker, for the attorneys to?
As we've said numerous times to you, multiple times, Mr. Lewis, it is a modification of the parent-child relationship. A party is entitled to seek the court's assistance with modifying orders with respect to children. That's the cause of action, as you would say, sir.
Okay. You mentioned that you're familiar with contract law. Is that correct, Mr. Conker?
I'm going to object to relevance for the issue of attorney's fees. Sustained.
The modification was necessary, you say, but you haven't given me the justification for cause of action.
I'm going to object to relevance of the issue of attorney's fees. Sustained. Any other questions for Mr. Conacher?
As to relevance of the attorney's fees, no.
Okay. What was the total amount of attorney fees that are requested? Total amount of attorney's fees requested is the amount of $22,342.37, Your Honor. Okay. The rest, I would like to ask Mr. Olivas only a few employment questions for the purposes of calculating child support. Okay. All right. Mr. Olivas, do you currently work?
What's the relevance for that question?
Objection unresponsive. The same. You need to answer the question. Do you work, sir?
Yeah, I work.
What do you do?
I have a wide range of different jobs, everything from construction to
Are you a salaried employee of the company, or are you a contract worker, sir?
I work for myself.
You work for yourself. So when you say you're a sole proprietor?
Whatever I need to do work-wise, what I do, and whatever I get paid is what I get paid.
So you get paid. How often do you get paid?
Depending on the job that I do. Different jobs pay for different things.
How many jobs on average do you typically have?
I wouldn't be able to give you a number. It varies widely.
If you had to average your monthly income from these jobs that you testify under oath that you do, what would your average monthly income be?
Average income? I would say zero, because I don't have any income.
So you don't make any money, despite work?
I have wages, but I don't have income.
What are your average monthly wages?
Well, can you define what you mean by wages exactly in the legal language that you speak? Because I'm not sure what you mean by it.
Sir, do you receive money to pay bills or no?
I receive different species of money, yes.
Okay, and on average, how much money would you say that you receive in a given month?
Wouldn't be able to average that out. I don't have a total. I'm sorry.
Is it more than minimum wage?
How much is minimum wage?
Well, I think the guideline says it's $7.25 an hour, if I'm not mistaken.
That would be income, wouldn't it?
Well, I'm just asking if you get money in a given month, sir, yes or no?
I would say yes, but I don't know exactly what you mean by that.
Okay. Do you make more than $100 a month?
Do I make? No, that would be counterfeiting money.
Okay. Do you receive as income?
I don't have income.
As we commonly understand income to mean, do you receive any income in a given month? Yes or no?
I don't understand what you mean by income. I don't have income. Okay,
you said wages, correct?
I have work and I exchange my labor for salary, I guess.
Salary, okay, so you admit to getting a salary, correct?
For certain jobs.
Okay. Well, what's the salary? What salary did you make for last month, June 2021?
I'd have to check records.
Any ballpark?
I can't. You're asking me to make up a number here. I can't do that on record. If you're gonna hold me to the same standard that you.
Because you don't want anyone to know what you make. Isn't that correct?
No, sir. I don't have income.
You didn't respond to Discovery with respect to providing your tax returns, correct?
I don't have any tax returns.
Okay, you didn't respond to Discovery with respect to any bank statements. Isn't that correct?
I don't have a bank account.
Okay. You're not currently disabled, are you, sir?
No, other than when I was recuperating from my broken hand, no.
So you're capable of having a full-time job, correct?
Am I mandated to have a full-time job?
No, I asked you if you're capable of having a full-time job.
Well, anybody is, I guess you could say.
Are you, sir?
I don't know why I would want a full-time job. I work for myself.
Okay. And when you say you work for yourself, how often do you work for yourself, on average?
It depends on what job comes up. I have to find a way to sustain my family one way or another, don't I?
I would agree with you.
Okay.
Absolutely. So,
how is that your business?
It's relevant for the purposes of calculating child support. I'm the one asking the questions, sir. We have further questions, Your Honor. I pass the word.
Okay, Ms. Sigmund? Yes, Your Honor. Any questions? No, Your Honor. Okay. Anything you'd like the court to know, Mr. Olivas?
Yes, I'd like the court to take notice of the divorce decree and its certain terms that it has under it. I'd like for the court to know that when this divorce decree was finalized, Rhonda Doe had plenty of time to look over the divorce decree. She stated earlier that she read the divorce decree, she understood it. She mentions that it was necessary to require the representation of Mr. Conker in order to achieve a modification. Yet in the divorce decree, give me 1 second to pull it up. It mentions that in the future, any litigation ensued should be paid for by the one that began the litigation. That would be here we go. It specifically mentions attorney's fees. I'll come back to that point. The responsibilities and the duties of I'll just go in order. Of each person, of each parent, when it comes to joint managing conservator, has to be that of communication between myself and her. She testified that she did not have access to communication with me, yet in previous court hearings she mentioned that she did have communication with me. She's taken a position that
Your Honor, I can use the facts that are not impediments. Okay.
The plaintiff in this agreement agreed to the terms and conditions of it. And so some of these terms and conditions are that in the best interest of my sons, me and her should work together. She says we have the right to receive information from the other conservator on the health, education, welfare of the children. We also have the right to confer with the other parent. And up until a point now, she's testified that she did not consult, did not confer, and did not talk to or communicate about things with me at all. We have a duty, and specifically we have, as joint managing conservators, to disclose if any conservator was to reside with someone or marry someone that is a registered sex offender under Chapter 62, and I never received that notice. Yes, the stepfather had that happen before the kids were born, but that's not the issue. The issue is that he routinely visits the home and does spend time with the kids, and I know that to be a fact personally. I met her family. I was married to her. She's never denied that he spends time with them. She just doesn't answer the question as to how much. My sons know him by first name. My sons know him and are familiar with him, and he does visit routinely in the home. She does not deny that. She just doesn't answer the question as to how much time she spends with him. She did not let the court know that this man visits the house regularly. And in fact, she has herself stated, and a quote from earlier, that he doesn't live in the home, yet he visits regularly. That I know that to be a fact. She has testified herself in previous hearings, and that she doesn't interfere with my time, my possession time. Yet I have submitted into evidence in prior hearings, and it has been admitted into evidence in the prior hearing, and this is leading up to it, so it is relevant because there was a notice that I sent to her in writing before this whole thing happened, where I talk about how she's withholding my sons from me. And
objection. Now he's assuming facts, not evidence. Presented nothing good. Sustained.
The evidence has been admitted. It was admitted in the first hearing. You meant that the court has access to all the admitted evidence. That's already in evidence. It's
no, sir. The court does not.
Does the court the hearings that happened with Associate Judge Busham, do those, everything presented there, is that even relevant right now, or is this a separate trial from that?
This is a final trial.
So, the evidence admitted in the other hearings are not relevant in this trial?
Did you present it?
Yes, I presented it in the other hearings, and they were admitted.
Okay, they were presented in the other hearing.
Further from that, Ms. Doe has not presented any evidence that I have, as she states, alienated my sons from her. She doesn't have any evidence, or did not present any evidence of any wrongdoing on my part in regard to the period of time that she says that I wasn't present. She hasn't presented any evidence or text messages or attempting to reach out to me in any way, shape, or form that I was not present. She just sued me and said that I wasn't. I don't know how to prove a negative. How do you prove you're innocent is what I'm saying, because she hasn't provided any evidence that I wasn't there. She hasn't provided any evidence, and she didn't sue me when I supposedly wasn't there. She sued me supposedly 2 years later, and or 3. She changes her mind on that, and the position is not consistent to how she would wait that long to sue me if I wasn't present. There's no evidence in the record that she has presented that she can prove that anything that she said was evidentiary. She's provided a whole lot of what she said, and she's provided, audio tapes, but where's the evidence that I didn't support my case? Where's the evidence that I was alienating them from her? Where's the evidence that she communicated with me in any way, shape, or form? She hasn't given that to the court. I don't know. At this point, I'd like to have a ruling on the fact that there is no evidence for that. I don't see how you could rule on a cause of action that has no evidence to support it.
Your Honor, I would expect further testimony from Mr. Oliva's 13 admissions that cover every single necessary prerequisite to the court to support a finding of a modification being in the best interest of the children.
I object. You did not. There was no prerequisite admissions. If there was a hearing and the judge heard it and then you received discovery, how is that an admission? You received all of your discovery.
Okay. Anything else, Mr. Olivia? Please do not argue with anyone.
I'd like to understand how that could be if I didn't receive any evidence for that. I did not see that. There was no discussion of that as far as evidentiary proof. So I'm just trying to understand where that evidentiary proof is for that.
Your Honor, could the Attorney General this last thing when he finishes?
Would you say you want to ask questions?
No, I have one last just closing remark. After looking at the case, the divorce decree did say that the father should carry government help with no cash medical reimbursement. And the mother's testimony and basically on our system, it showed that she had actually been carrying the government help, not the dad. So that definitely needs to be modified, and there definitely needs to be a cash medical reimbursement.
Okay. Anything else, Mr. Oliva?
Yes. On page 24, as far as what the agreed contract between Rhonda Doe and myself.
That's irrelevant. We're here on a modification.
Well, the modification is based on the decree, is it not?
Is there anything else, Mr. Olivas?
I just want to know if you're making a judicial determination that I cannot comment on the divorce decree that's a standing order in this case.
The court's ready to make a ruling.
So are you making a determination that I cannot comment on the standing divorce decree that is in this case?
For the 100th time, I don't know how to make you understand that we're here on a modification.
There has to be a basis for it, and there's a custody agreement here.
I have it in my ruling.
Well, I'm not being allowed to testify as to, so I guess I'm just going to stay silent and wait for your ruling, and we'll see what happens.
Page 20.
Anything else from anyone? Anything else, Mr. Olivas?
No, simply put, I just like to notice the court on the last part of this this decree right here that I'm pulling up. It says that without affecting the finality of the final decree of divorce, the court expressly reserves the right to make orders necessary to clarify and enforce this decree. It mentions that it was ordered that the relief request, if it wasn't requested or not expressly requested, it was denied. It said that this was a final judgment and for which led execution all the writs and processes necessary to enforce the judgment. The judgment finally disposes of all claims and parties, and it was appealable, and Rhonda Doe never appealed it and never communicated as to why she would even do a modification without speaking to me. This decree was supposed to be a best interest, under the best interest, and both of us agreed to it. Yet, as a joint managing conservator, she has failed to communicate in any way, shape, or form, and she hasn't had any evidence to prove that she did do that. And I don't have that. So that's the last thing I'd like to show the court, is that she never acted as a joint managing conservator, and that's been the issue the whole time. So just on that note, we have this decree, we have no evidence of her working with me. So I'm sitting here trying to understand what's going on, but no answers are being given or otherwise as to why I would be adjudicated without any just cause.
Okay, anything else? All right, both sides rest and close?
Yes, Your Honor.
Yes.
Mr. Olivas?
Yes.
Okay. The court finds that there has been a material substantial change in circumstances with the children or parent that warrants a modification in parent-child relationship. Based on the testimony and evidence, the court finds the following as being in the best interest of the children. Court finds that the father was under threats from a drug cartel and did not visit with his children during this time. Court finds that the father talks to the children regarding the case and makes negative remarks about the mother. Court finds that Ruben's education performance has declined since the modification has been filed. Court finds that Ruben tells his mother that he won't go with her unless she drops the court case. Court finds that the dad has attempted to alienate the children. Court finds that Ivan stated in the evaluation that the father makes disparaging remarks about his mother and constantly talks about the case. Ivan states that he is stressed out and he asks his dad not to discuss this, but dad doesn't listen. Court orders the parents as JMC, with the mother determining the primary residence in Dallas and contiguous counties. The mother will have exclusive right to determine the primary residence, make educational decisions, and make psychiatric and psychological decisions. All other rights are independent. Court orders the father to have standard possession and access of the children every first, third, and fifth weekend of the month, beginning Friday at 6 p.m. and ending 6 p.m. on Sunday, standard holiday in summer. Court orders the father's current child support in the amount of $400 per month, beginning August 1st, 2021, every first of the month thereafter. Court orders the mother to continue to maintain health insurance for the children through the government entity, 50/50 uninsured. Court orders the father to pay cash medical in the amount of $100 per month, beginning August 1st, 2021, and every first of the month thereafter. Court orders the children to begin counseling with Dr. Elena Anderson, and the mother is to be incorporated into this counseling. The cost of the counseling shall be paid 50/50 by the parties. Court orders that the children shall not be left alone or without supervision with the mom's stepfather. The mother's request for attorney fees is granted in the amount of $22,342.37 to be paid directly to Attorney Conacher's firm, Warren and Migliaccio. Case set on 8/802, enter order dismissal, August 13th, 2021, 8:30 a.m. All right, thank you.
Thank you, Your Honor. May I be excused?
Yes.
One final question. I'd like to know what species of money that you would like that paid in.
Thank you, sir.
No judicial ruling on that?
Okay, we are on to the next case. Are you all ready? Mohammed Maharami and Mahia Jelia.
Yes, Your Honor.
No ruling on it.
You can appeal it, right?
Yes, I'm gonna appeal it because she didn't prove any jurisdiction. So when I was asking her for very specifically what it is that I did or what it is that I was gonna do,
I searched up her name and she hasn't. She's been.
yeah, I know what she was gonna be like. So she from
judge, right?
yeah, from the very beginning when I said he's not an attorney and I wanted him to prove it, she said no, I know he is and blah blah blah. So when I told her in the hearing that I accused her of, she was gonna rule on his favor,
And he probably paid her.
and so
¿Y los niños van a contribuir?
So when I asked her to give me or let him prove his case, she basically said, I know he's an attorney, and so she was joining him as on his side.
Yeah, we saw that.
And then when I was like, okay, well, can you let him show me that? Can you give me that? She's like, no. So she didn't let me do an offer of proof. She didn't let me do anything that a judge is supposed to do.
What I'm getting is that you were supposed to put all your proof at the end for this hearing,